Every college has a code of conduct, but how do they relate to the law? My name's Annie. Learn more on this law you can use. Welcome to the Ohio State Bar Association's Law You Can Use, where we answer commonly asked questions about different legal topics. Today we're discussing college codes of conduct, and I'm here with Mark Weiker. He's a partner at Albeit Weiker here in Columbus. He represents parents, students, schools, and school employees, and he practices school and education law. Thanks so much for being here, Mark.
My pleasure. Thanks for having me.
So, college codes of conduct are sets of rules that govern students' behavior, and almost every higher education institution has them. How do courts view these codes of conduct?
Courts view the codes of conduct like a contract. So, on one hand, you have obligations of students and their behavior on campus, and on the other hand, you have the school's obligations, which includes the procedure that they will follow if there's some alleged violation of the code of conduct. That would include the due process rights, the hearing procedure, and the procedure for appeal.
Mm-hmm. They're viewed as contracts. Is there a point where students sign this contract, or are they implicitly signed by being accepted into the school?
Good question. Students are really implicitly signing the contract when they step foot on campus and pay tuition. Mm-hmm. And the code of conduct itself may not be delivered to the student. In fact, usually it's just online and the school directs the student to the code of conduct, typically during orientation. But no, that it does not have to be signed, but they are bound by it by paying tuition.
Mm-hmm. And what kind of behavior do these codes typically address?
The behavior is really broken up into three different categories typically. You would start with academic misconduct, so that would include things like plagiarism, cheating on tests, or violations of the course syllabus, or the exam rules, for instance. Mm-hmm. And then in the second category, you really have student behavior. So that includes things like hazing and harassment, alcohol and drug violations. And then the third category is sexual assault or sexual harassment, and that's covered by a typical or a separate procedure, which is the guidelines are taken from Title IX.
So proceedings, when it comes to violations of college codes of conduct, are different than what we think about when we think of criminal proceedings in a courtroom. How do they differ?
The biggest difference is the standard that's applied in the code of conduct proceeding. The standard is a preponderance of the evidence. And what that means is that it's more likely than not that a violation of the code of conduct occurred. That's much different from what students might be familiar with, which is the beyond a reasonable doubt standard that's applied in the criminal context. When you go through a proceeding, whether that be a hearing before a full panel or an administrative hearing before an individual, the standard that's applied it can be based on a lot less evidence than you would need for the beyond a reasonable doubt standard. And in fact, students can be suspended or expelled from school and left with hefty student loan debt, all based on the determination that it was more likely than not that a violation occurred.
Mm-hmm. Is it handy to have an attorney for one of these proceedings?
It can be very helpful to have an attorney. There are occasions where you may not need an attorney if the alleged violation is not that severe. But in many cases, an attorney can help you understand your choice in terms of the hearing procedure, again, an administrative hearing or a full code of conduct hearing. In some cases, you can accept responsibility and then accept the sanction that flows from that. There are also constitutional due process protections that apply, and so minimal levels of due process that have to be applied by the school. And also for students with disabilities and other categories of students, there are additional protections, usually based in federal law, that an attorney can advise you. The last thing an attorney can do is help you craft an effective appeal letter. Mm-hmm. And the code of conduct typically includes 2 or 3 bases for appeal, mm-hmm. and an attorney can really help you make sure that your appeal letter is effective and based on one of those points.
Mm-hmm. All right, well, thank you so much for answering all our questions about college codes of conduct.
Thank you.
If you have a legal topic that you'd like to learn more about, follow the Ohio State Bar Association on Facebook, Twitter, and LinkedIn, and write to us using the hashtag LawYouCanUse. And to learn more about college codes of conduct and more than 600 other legal topics, go to ohiobar.org/lawYouCanUse. And thanks for joining us.